Looks like you and Ms. Krusich either are or were in a relationship.
Dated. We don't live together. Never have lived together.
But you dated.
Yes, Your Honor.
And both she and Ms. Gogan work at DSHS.
Correct, Your Honor.
Okay, as do you.
Yes, 30 years.
Okay. And are you in their supervisory chain of command?
Can I explain that to you, Your Honor? So, I work for the Office of the Secretary. Mrs. Gogan, she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where part and where the problem lies, is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, she sent these memes and information around to the office. And if you see the one that I sent you, where it says in there, do you see who's on there? And I'm a coworker. Where she says, dude, I wouldn't normally message a coworker, but I can't stop laughing. So here it is in this office where you're the admin assistant to the second highest person in our administration. And now how am I supposed to work with you every day and trust when you're discriminating and doing all these acts of inappropriate behavior in the workplace? And so part of my action is I'm probably going to file a lawsuit against her. And so I need that protection for me, because per our policy, this administrative policy, she's probably going to lose her job because of that. She even the words that she uses, where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. And then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes a comment and she's laughing her head off.
I'll be honest, there's just something hilarious about watching a grown man melt down because someone said mean things to him on the internet. I can't help it, it cracks me up every time. And here's the kicker. A lot of people don't realize this, but Chili DeCastro, yeah, the guy behind the Delete Laws YouTube channel, has tried to pull the exact same stunt with me. He's filed multiple lawsuits, both federal and state, because I hurt his feelings online. I'm not joking. You're literally looking at part of one of his lawsuits right now, where he claims I called him names like human crash test dummy, idiot Karen, bona fide dumbass, monkey grifter, crayon taste tester, neander Karen, jackass, the Shaquille O'Neal of mental midgets, height-deprived Karen, sovereign citizen, and a really large chipmunk. And honestly, I still stand by every single one of those. That list isn't even complete, but let's just say this male Karen is heading straight for the same fate as that really large chipmunk neander Karen, because here's the truth. Saying mean things about people on the internet is protected by the First Amendment. So cry harder, Chili.
That in itself, and then I'm the senior administrative officer there. I'm third from my boss in the department. I've been working for DSHS for 30 years, Your Honor. I've attained my MBA. I have a HRMS background. I have a Sigma SME. I've been in the Army 20 years. Currently, I own my own business. All these things that she's doing affect me greatly. And it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number 3, actions that violate this policy aren't limited. Violations via phone, email, text, social media, electronic communication. Such behavior can also be outside of work. it specifically speaks to this in our administrative policies.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So,
okay, and what about Ms.
So let me finish, please finish, Ms. Gogan. So I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are putting photos online without the permission of
who's doing it?
Are we dating him too? It's a site it's a group that's embedded into Facebook. And currently I have with this Attorney General's to take that website down because they are putting males photos up without their permission, and they are women who are on there that are anonymous. So you don't know who it is. It could be any bandwagon person like Ms. Gogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. It's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where it's very, very libel and slander. So I'm working on doing that for that website. Mrs. Krusich, she was upset that I stopped dating her, and I sent her home one night. And then here, when you're looking at a couple of those, her first posting, she tried to be anonymous and said that this guy was trying to get me to go to work or to blah blah blah, and I sent the photos on there. It didn't look like I tried too hard to get her there. She looked pretty happy there. And then currently, not only does she work for DSHS, but she also has a few things of mine, and she's saying things that are disparaging on that website, and now she has her name on there, and she's identified me where I work, which is very slanderous. I'm currently in my position. I'm in the Army Reserves. I'm also a voting member for BHR in Olympia, and she knows several of those folks. So here it is, you're saying slanderous and libel things, and I could lose that spot, which is a very coveted position for me to be on a voting board here in Olympia. It took me a long time.
Well, if that board is so petty that they'll believe anything they read online, maybe that position isn't as prestigious as you think it is. And here's the flip side. If you actually care about keeping that spot, maybe don't date your coworkers. That way, when things go south, people won't be roasting your romantic failures all over the internet.
For you to achieve what you want to achieve, because one of the things we don't do with the protection order process is keep people from saying bad things about other people. It's their First Amendment right. And so I get this all the time from people who say, you wouldn't believe what they say about me. None of it's true. And they post it on social media. They broadcast it to the world. They call me a pedophile. They call me this. They call me that. And we say, sorry, we can't do anything about that.
I agree with that, Your Honor.
So I don't know how I can do something about this.
For me, it's work. I have to.
Right. But that's.
Ms. Goldman can't come.
No, I understand your position. This is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens, Your Honor?
Well, we can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired, because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. I don't know if I'm pronouncing it. Yeah. And same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy, and for doing so, here's the sanction, whether it's whatever it is, firing or loss of pay or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate procedure. You can You can file civil lawsuits
Oh,
against
yeah.
them for
Yeah,
the
that's-
damage.
That's coming. Yeah,
That's you feel
Yeah.
has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit, but this process isn't meant to address them. So you're not going to get any what we would call a remedy out of this. I can't give you anything that will address it. So, I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear, I'm not saying that what you're having to deal with is too small for this or anything. It's just this is not the appropriate process for that.
Oh, that's fair. Yeah, for me, it's about exhausting all my needs.
Yeah.
So
No,
it's not an end all for me. It's just another bullet in the process for me.
Yep, I get it. Certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are black males that are like me that have been dealing with this on these websites, and I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there, and I'll find it. I will.
Yeah, persistently stupid. Because sure, with even the slightest bit of research, you'd realize Washington is a two-party consent state. But that only matters when you're secretly recording someone. What it doesn't mean is that both people have to agree to being criticized online. That's not how this works. Alright, moving on. For our next hearing, we're heading down to Florida, where a sovereign citizen gets one of the best deals I've ever seen from a prosecutor, but true to form, his own stupidity won't let him take it.
You had continued Kareem Williams from, I believe it was last week, the out of custody pretrial, because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete that term. Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges would be dropped.
If you successfully...
If you did all those terms.
You have to abide by those terms and conditions, and the case would be dropped.
Could I
I've got someone who can answer all your questions, and even the follow-ups you haven't thought of yet. But hey, don't let me keep you from your lunch or your box of crayons.
shortly? I didn't really get all I really spoke over, what we went over was the terms.
We had several phone conferences that were scheduled.
Yeah, we missed a lot. Due to the time difference.
Sir?
I said, well, we missed a lot due to the time difference.
He was on Eastern time, and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state?
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are. I can
I'm just
tell,
asking
I can
questions.
tell you're not. Your possession of a controlled substance, giving false name, causing adverse effect, I guess there could be a victim on that, and resisting officer without violence. I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And it will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I'm on Central.
Central Standard Time. You're on Eastern Standard.
So wait, you're telling me this guy has to subtract 1 hour from his local time just to maybe get his case tossed for free? Yep, this sounds about right. All right, now let's move on to our final hearing. This one features a sovereign citizen who calls herself House of Jennifer, which, I'm guessing, is just a fancy new way of saying asterisk Jennifer of the family.
WB Funding LLC versus Jennifer Moore. The matter is before the court, set on for a motion. Counsel, your appearance regarding this matter, please, sir.
Thank you, Judge. May it please the court, I am Attorney Richard Grusin, and my bond number is 35222, and I am the attorney for the plaintiff.
All right. It appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right. And do I have Jennifer Moore on the Zoom?
Yes. Good morning, Your Honor.
All right. Thank you, Ms. Moore. Good morning to you, ma'am. All right. And it appears that the plaintiff is moving. Sorry. Yeah. Well, no. I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Now, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVMV Funding when I checked my credit score. And that's how they were able to reach out to me. They were sending information to a different address. And according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail and so on. So, and I reached out to the creditor, and they said that they gave my account to Midland. I have since resolved the issue with Midland, and it is paid. I then reached out to LV. They failed to give me all my information document needed, and now we're here. So I apologize for not appearing in court when I was going through my difficult times in life.
I love how sovereign citizens always think they can just skip a court date and somehow nothing bad will happen. But the moment those wage garnishments hit their paycheck, suddenly they find their way back to court real fast. It's a pattern at this point. A judgment gets entered because they didn't show up, and then they waltz in later with some brilliant excuse, like they were choking on paint chips and missed court because they were too busy drinking paint thinner to survive. But here's the thing. Having a good reason for missing your court date is only half the battle. You also need something called a meritorious defense, and that's where most of them crash and burn.
So your response, I do see you follow it response. So,
I'm not sure how to respond to a lot of that stuff, Judge. I can tell you that I have been retained as the lawyer for LBNB funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the Register of Action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so the case continued. I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument that, quote, the matter that's before Your Honor was with Midland funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
this case was argued. I'm not done, madam. The case was continued to press, and so here we are now with good.
Mr. Rosen, I'm stopping you. I'm stopping you because your device is breaking up, and that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad, and so you're going in and out. You indicated the last thing that was clearly heard was that you prepared to offer a satisfaction of judgment. You said only about $89 or so was owed.
Exactly. Yeah, that's right.
After that, we weren't able to hear you very clearly.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment, well, I'm prepared now, to file a satisfaction of judgment because it's all paid. I have no idea what the defendant is otherwise arguing about, but on that I rest.
Well, for the record, Your Honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LBNB Funding, and that's it. This is not a case that went passed around the room like last year's potato chips. It's a one-time assignment from Credit One Bank to Midland to LBNB Funding. Midland Funding is not involved in this, and I do not represent Midland Funding in my office.